let's get down to business with that first practice essay. To refresh your memory, I'll read through the facts. On January 1st, 2017, Alice called Betty and asked her to sing at her wedding that was to take place on April of 2018. Betty was excited about the opportunity, as she had never sang publicly, and readily agreed. Before they ended the phone call, they agreed on all material terms. Betty later released a #1 single. She became quite famous, and she went on world tour. Betty called Alice the week before her wedding and told her that she would be out of the country on Alice's wedding day and could not perform. So the questions are, was there a valid contract formed between the parties? And number 2, assuming a valid contract was formed, what are Alice's options? So whenever you're sitting down to tackle an essay, quickly look at the call of the question first. Here, as we just mentioned, we're asked 2 questions. Number 1, whether that contract was formed, and 2, Alice's options. So without even reading through the fact pattern, we already know that this is a contracts question and that we need to discuss both formation and breach. And if you have a very good understanding of the law and how it fits together, you also already have an idea of how you're going to organize your answer without even having read the question. We're going to start by stating what law applies. Is it the common law or is it the UCC? Then we need to discuss mutual assent and consideration and defenses to formation, and then finally breach. So I would encourage you to quickly write those issues in outline form as you work through the facts. That way, when you encounter a fact that fits into one of those issues, you can include it in the outline so that it can become part of your analysis when writing your answer. So now that we've read through the facts and we have a general outline of our issues, let's talk about them. The first thing that we notice is that Alice called Betty. Now I call this red flag fact. That alerts you to the fact that this is an oral contract, in which case the Statute of Frauds might apply. So in that outline, under defenses to formation, I would write Statute of Frauds. And as we read, we see that that phone call was made on January 1st of 2017, and that the wedding is in April the following year. So that's another red flag fact. It should trigger you to talk about the 1-year provision under the Statute of Frauds. So let's go ahead and put that in your outline under the Statute of Frauds. So going back to our general outline, we know we need to start with the applicable law. And now we know that we're dealing with services, singing at a wedding. So we can put common law service contract under that heading. So move on to mutual assent. We need to find the offer and acceptance. Now Alice asked Betty and Betty readily agreed. And the facts also state that they agreed to all material terms. So there doesn't really seem to be much to discuss here. So we can quickly mention it and move on. But we have to focus on consideration as well. After all, we can't have a valid contract without mutual assent and consideration. So remember also when you're writing your essays to always use the IRAC format to discuss each issue. The consideration here is money in exchange for the service of singing. So we have a bargained for exchange. Then we come to defenses to formation, specifically, as we've already identified, that Statute of Frauds issue. But just in case, let's scan the facts and compare it to your memorized checklist of all possible defenses to formation to see if you can see any other defenses that might be raised by the facts. There doesn't appear to be any here, so it's okay to move on. Okay? But as we mentioned, we will have to discuss that 1-year provision of the Statute of Frauds. We're not done yet. There's 2 questions in this fact pattern. Question 2 asks us about Alice's options. They tell us that Betty called Alice a week before the wedding to let her know that she would not be performing. Now, because you know the law so well, you know that that is an anticipatory breach. So you want to write that on your outline as well. Now that we have our outline down, let's use it to write our answer. Again, IRAC. Issue, rule, analysis, and conclusion. Make sure you use that template to write about each issue. If you're not familiar with IRAC, look it up. You have to know this stuff. And make sure you use the facts in your analysis section to guide the reader towards your conclusion. Because if you simply just state a conclusion, you're not going to get any points for analyzing the issue, which is where your points will come from. So let's use our outline to help us write this answer. Okay, so our first question is whether a valid contract has been formed. So we're going to make that a header. And we need to start with the issue of what is the applicable law. Then state the rule. The UCC governs contracts for the sale of goods, while the common law controls contracts for services. Let's apply that rule. Because this contract involves singing at a wedding, it is a contract for services, and the common law controls. Was there mutual assent? This is our next issue. Mutual assent, here's our rule, is achieved through the process of offer and acceptance. Here's our analysis. Alice called Betty to ask if Betty would sing at her wedding. This was the offer because it was communicated directly to Betty. Betty accepted when she readily agreed. The facts also state that they agreed to all material terms. So mutual assent through the process of offer and acceptance was achieved. Third issue, was there consideration? Consideration is a bargained for exchange. Here, the parties bargained for the service of singing in exchange for payment. Therefore, consideration exists to support the promises of each party. Now to the meat of the question, defenses to formation. Is there a defense to formation here? Here's our rule. The Statute of Frauds requires that certain contracts be in writing in order to be enforceable, including contracts that, by their terms, cannot be completed within 1 year. For your analysis, you state that because this contract was made on January 1st of 2017 and would not be fully performed until April of 2018, it's impossible for the contract, by its terms, to be completed within 1 year. We're going from January of 1 year until April of the following year. Therefore, it must be in writing in order to be enforceable. And because it's not in writing, it's not enforceable. Okay. Some students stop here and forget about that second issue. Don't forget about the second issue. It says, assuming there was a contract, what are Alice's rights? Okay, so we'll start here with if the contract was enforceable, then Betty's statement that she would not perform is an anticipatory breach. An anticipatory breach occurs when a party to the contract unequivocally states her intention not to perform in advance of the performance date. Now, when that happens, the non-breaching party has two options. They can either terminate the contract immediately and sue for damages, or they can wait until the time of performance is due and then sue. So in this case, Alice should probably just suspend her own performance under the contract and find another wedding singer. And if that singer ends up costing her more, Alice can sue Betty for the difference in price. And that's really it. I hope this helps. If nothing else, you now have an idea of how the Statute of Frauds and the concept of anticipatory breach can be tested on an essay exam. Now, if you didn't come anywhere close to this answer when writing it on your own, I encourage you to try again, knowing what you do now. And if you find yourself still struggling, please do consider reaching out for some private tutoring. Until next time, keep practicing.